Lilburn exploited the power of the printing press to propagate his views and energize his supporters. His secretly published diatribes were passionate, rousing, and seditious, and publications such as this were distributed up and down the country by a network of his sympathizers.
Freedom of speech was limited in Lilburn's day.
Lilburn's words managed to infuriate every administration under which he lived.
They'd repeatedly lock him up to shut him up, but Lilburn had a crucial legal weapon on his side, one enshrined in the Petition of Right.
There have been many ways by which people have tried to escape imprisonment, filing through bars, climbing over walls, digging tunnels, but none has the simple elegance of using a small piece of paper to fling open the doors. This is the magic of habeas corpus.
John Lilburn thought this piece of paper could be the key to his freedom.
Here's how habeas corpus works in practice. A document known as a writ is delivered to the jailer saying, "We direct you to have the body," habeas corpus in Latin, of, say, Harry Potter, before this court, along with the reason for detention. If the jailer cannot satisfy the court that the reason is lawful, then Harry Potter walks free. Habeas corpus is a remedy against arbitrary arrest and unlawful imprisonment.
Lilburn employed habeas corpus more often than anyone in history. The results were more symbolic than actual. He was able to highlight his predicament and embarrass the authorities, yet he'd still be sent back to jail. If anything showed how the law was being subverted, it was this. The authorities knew they couldn't get away with it forever. In March 1649, Lilburn's latest pamphlet attacking Cromwell's regime got him arrested. While Lilburn was being held, Parliament created a new law. It made it treasonable to call the government tyrannical or unlawful in print. A mutiny in Oxfordshire brought things to a head. Lilburn's pamphlets were blamed for goading the troops to revolt. Cromwell put Lilburn on trial for publishing seditious pamphlets under this convenient new treason law. Cromwell left for Ireland, safe in the knowledge that Lilburn was all but a dead man.
The evidence against Lilburn was very strong. This time he had been lawfully detained, charged and put on trial, and in those circumstances habeas corpus was both irrelevant and impotent. Worse still, Lilburn was going to defend himself, and as we lawyers like to say, he who represents himself has a fool for a client. But John Lilburn was no fool. He was perhaps the greatest amateur advocate ever to set foot in an English court. At his trial, Lilburn won important rights: the right to a vigorous self-defence, to challenge seeming unfairness in court procedures, and to take comfort breaks.
Lilburn had woven the law into a safety net that ensured Parliament couldn't silence him. Now, just as Charles I had used the Star Chamber, Cromwell needed to find a way of dealing with Lilburn outside the normal parameters of the legal system. The next time Lilburn stepped out of line, Cromwell would have something up his sleeve. Before Lilburn could issue a writ of habeas corpus, he was shipped across the English Channel, beyond the reach of the law.
On this offshore military outpost, the normal protections of English law were almost impossible to employ. Jersey was Oliver Cromwell's Guantanamo Bay.
Lilburn's extraordinary rendition took him from the relative comfort of the Tower to here, Montorgueil Castle. Cromwell wasn't prepared to take any more chances with a man like John Lilburne and dispatched him here to Jersey. Isolated on an island, out of sight and out of mind, he was beyond the effective reach of habeas corpus.
Lilburne was offered his freedom if he would just stop agitating against the government. But being Lilburne, he would not back down. A year's imprisonment in the conditions of this castle, however, if it couldn't destroy his spirit, left him a largely broken man.
The damage to his health proved mortal. John Lilburne died, aged 42. But his legacy continued. Jersey was an island-sized loophole in the petition of right. All had access to habeas corpus, except in places such as this. Whilst that might suit the government, voices of discontent were muttering on the back benches.
Increasingly, MPs were showing disquiet about this legal sleight of hand, and how the issue was resolved makes one of the most peculiar parliamentary tales.
A habeas corpus bill was drawn up for prevention of imprisonment beyond the seas. No one would be placed in Lilburne's legal limbo again.
Now no one could be imprisoned beyond the seas. Nowhere in the empire was beyond the reach of habeas corpus, a fact that would later have huge, if rather unforeseen, consequences. And all thanks to one fat lord.
In 2004, the U.S. Supreme Court ruled that detention in Guantanamo Bay was illegal because it infringed the Habeas Corpus Act. America still looks to pre-independence English law for precedent. Over the course of the 17th century, the liberties of the English had undergone an extraordinary change for the better. This was thanks not only to men like Edward Bushell and John Lilburne, but also to the legal instrument at the heart of their stories. Habeas corpus had served Englishmen well. Could it now deal with an horrific abuse which the English were inflicting on others? 1771. The Thames docks. A legal document is raced down to a ship that is about to set sail with its cargo for Jamaica.
The document required the ship's captain to produce his cargo before the Chief Justice. The document was a writ of habeas corpus. The cargo, a slave called James Somerset.
By putting Somerset in chains, the ship's captain had become his jailer, answerable to the law. And as we have seen, habeas corpus gives a prisoner the power to compel his jailer to justify his imprisonment. A realization swept across the slave trade. The very legality of slavery itself was going to be tested in court. Fortunately, while Somerset was on the run, he had encountered abolitionists. Their leader, Granville Sharp, was seeking to challenge the legal basis of slavery. When he heard of Somerset's plight, he knew he had found the perfect test case. At bottom, this was an argument about whether a slave had rights on British soil.
Rule Britannia, the popular anthem of the era, boasted that Britons never shall be slaves. Now the legal system was being asked, can slaves ever be Britons?
Did the law regard a slave as property, like this boat? A writ of habeas corpus in this case would be meaningless. Or would the law see a slave as a human being? If so, habeas corpus could challenge their transportation out of the realm without their consent. Ultimately, the judgment in this case would reverberate on both sides of the Atlantic. The case went to the very top, to Lord Mansfield. The slave traders could have expected Mansfield to be their ally. Of Scottish noble birth, he embodied the establishment, from his imposing home, Kenwood House, to his rulings embracing free trade. He had been leader of both Houses of Parliament and was the highest judge in the land, Lord Chief Justice.
In this very fine library, the erudite Lord Mansfield studied the law. And there he is, in all his glory, robed in ermine, reading Cicero, with Homer inspiring him and the Pillar of Solomon behind him.
As the case ground on in Westminster Hall, Lord Mansfield is said to have proclaimed, "Let justice be done, though the heavens fall." Oh, it was a staggering decision. How had Lord Mansfield come to rule in a mere slave's favour?
In his judgment, Lord Mansfield said that the state of slavery is of such a nature, so odious, that the English common law could never accept it. Now, whether he meant by this to ignite a spark that would end slavery is unclear, but that is how his judgment was interpreted both here and abroad. One single writ of habeas corpus had released not just one man from bondage, but was to mark the start of freedom for all the 15,000 slaves then in England.
Habeas corpus remains part of English law, but it rarely needs to be used today. In my entire career, I've never had to seek it on behalf of any of my clients, nor has anybody else I know. We simply take it for granted that everybody has the right to know the reasons for their detention, just as they have the right to a fair trial by an independent jury under the auspices of an impartial judge. Arbitrary action by the state at any stage in the legal process is something we hope, like slavery, has been consigned to history. We may regard these liberties as free-born rights, to use John Loburn's words, but we mustn't forget just how hard won they were.